There are many types of business forms and structures when you want to set up a business, from simple to the complex. Generally, an organization can be either unincorporated or incorporated. An unincorporated business has no separate legal entity of its own, and therefore the owner has to take the responsibility of the risks and liabilities involved in the operations. An example of this will be sole trader and partnerships. Incorporated business organizations, however, is a legal entity in its own right. It has to be created by a legal process. The operations will be continued despite change in memberships, for instance, public and private company. More recently, a new types of business structures, namely limited liability partnerships, become available since 6 April 2001, when the LLP Act 2000 came into effect. I've heard about limited company and partnerships, but what is limited liability partnerships? This is what we are going to talk about in this video.
Doors closing.
Briefly saying, LLP is a legal entity which categorizes in an incorporated business forms. It provides a limited liability features of the company while providing the owner flexibility of the partnerships. The persons involved in LLPs are called members as opposed to partners. There is no legal requirement for an LLP to have a written partnerships agreement, although in practice they generally do. If the members has not agreed on various matters, the memberships will be subject to the rules set out in the Limited Liability Partnerships Act 2000 and the 2009 regulations. The deferred provisions of the statutory act state the rights and duties of the members. Here are some of the important ones. All members are entitled to share equally in the capitals and profits of an LLP. Every member may take part of the management of an LLP. No persons can be introduced as a new members or given an interest in an LLP without the consent of all existing members. A member cannot be expelled by the majority of other members unless there is an express agreement between all members. No members are entitled to payment for participating in the business or management of an LLP. Now, let's talk about the main procedures and conditions to set up an LLP. In order to form a limited liability partnerships, one has to fulfill the following criteria. First of all, there must be at least 2 members with no maximum limit. The only restrictions of being a member is persons who have been disqualified from acting as a company director, a member of an LLP, or involved in an undischarged bankrupt before. Secondly, the document which lists the names and office locations must be registered with the Registrar of Companies at Company House. The name of an LLP must end either with the words Limited Liability Partnerships or the abbreviations LLP. In the UK, there are 2 ways to incorporate an LLP. The first is to submit your applications through web-based electronic service. The fees for this is £13 or £30 for a same-day service. Alternatively, applicants can also send paper documents to Company House, which take longer times to process than electronic documents. The standard fees for this is £40 or £100 for an express same-day service. Last but not least, one should also be noticed that LLP are not applicable for all activities, for example, non-profit making event. In fact, limited liability partnership is very different from general partnerships under the Partnerships Act 1890. even though there is some similarity. In an LLP, each member has joint and several liability, which mark the importance different from traditional partnerships. The main features of an LLP is that it is taxed as partnerships, and by law, it has to prepare and publish annual accounts. The forms and contents of the accounts and audit requirements are the same as for limited company. In the UK, if the revenue is more than £81,000 a year, it has to register for VAT. LLP can even issue debentures and create charge on its assets. Therefore, in some respect, limited liability partnership is more likely a limited company, and it can be considered as a hybrid between a partnership and limited company. So the question is, why choose LLP as a business form? There are a number of commercial reasons why a business may be better placed by operating as an LLP rather than as a limited company. Nevertheless, the advantages and disadvantages of LLP has to be assessed by entrepreneur. Just like this river, there is nothing on the surface, but we don't know what lies underneath. Next, the rest of my team members will discuss the limitations and benefits of LLP and why there are so few LLPs in the UK.
Okay, having introduced the features and procedures of LLPs, it is time to evaluate the advantages and disadvantages of LLPs. As a hybrid of traditional partnerships and companies, LLPs can provide a number of commercial advantages, which are attractive for business to convert to an LLP. First of all members of an LLP have limited liability. This is the most significant benefit of LLPs compared with a general partnership, in which each partner has joint and several liability. More specifically, the LLP is a separate legal entity, so its members will not be personally responsible for the debts of the LLP, except in certain circumstances where the LLP becomes insolvent, and members' liability is only limited to the amount they invested, which is quite similar to that of the shareholders of the corporation. Besides, generally, a member will not be liable for the misconduct or negligence of other members, so the risk of taking excessively legal responsibility of members will be minimized under this organizational structure. In addition, the LLP enjoys a favorable tax treatment as an ordinary partnership. For instance, only members will be taxed based on their income, but UK corporation tax is not paid. In contrast, both personal income tax and company tax have to be paid in companies. Also, there could be savings in national insurance contributions, because they just need to pay a lower level of national insurance contributions, whereas directors and the employees in companies have to pay national insurance contributions at a fixed rate depending on their profits. So the members' tax burden will be reduced significantly compared with companies. Moreover, it is fairly easy to establish and flexible to manage an LLP. An LLP can be cheaply and quickly incorporated in the company's house, and there is no need to prepare or fill at the company's house any written agreement between members as to the operation of the LLP. Besides, each member of LLPs can play an active role in the management of a LLP, which is very different from companies in which managers such as directors and CEOs have to be elected at the general meeting by shareholders. However, there also exist a couple of drawbacks of LLPs, which include that many provisions of the company law, such as Company Act 1985 and 2006, apply to LLPs, and each LLP is required to submit annual return. Firstly, each LLP is subject to the same rules as a private limited company for the registration of the accounts at the company's house. For example, according to the Company Act 1985, LLPs have the obligation to go public with their accounts by delivery of a copy of the accounts and the auditor's report to the registrar for the inspection of the public. Accounts must be filled and audited to show a true and fair view under generally accepted accounting practice, and must be properly translated if they are delivered not in English. Therefore, in this case, LLPs may face more pressure from the public or even the customers. For instance, if the LLP is seen to be doing well and making large profits, customers may claim that they are being overcharged. Furthermore, each LLP needs to submit annual return, which sets out the registered details of the LLP, such as business activities and members' places of residence, to the registrar every year. In general, most professional partnerships in particular have a great attachment to the secrecy that partnership status offers them. If the personal information of members of LLPs is released to the registrar or even the public, then their privacy will be exposed to a large extent. In general, more legal firms mean more choices, but at the same time mean spending more time and money on administrative issues rather than running the business. And the financial disclosure or transparency is the inevitable concomitant of limited liability in the UK. All of the above requirements mean that each LLP must appoint an auditor or auditors, and the disclosure, filing, and accounting requirements tend to produce more efforts and operational costs, which is not less burdensome than those for limited liability companies. Some empirical research makes clear that the cost of filing and disclosure is far more of a burden to small business. As a consequence, this financial disclosure requirement is enough to deter some professional partnerships from using the LLPs. Next, Javario will elaborate more and explain why there are so few LLPs in the UK in terms of its internal and external factors.
As with all other business structures in the UK, LLPs have a number of advantages and disadvantages, both internally and externally. There seem to be very few LLPs in the UK, so what's the major reason behind that? There must be a major hindrance. I will focus on three main points. My first point is that LLPs have an extremely confusing management structure. In LLPs, this odd management structure gives various titles to its members, such as members, managing members, presidents, or partners. Because of these various titles, it can be sort of hard to find out who the authoritative figure is with who to establish a contract in the LLP. My second point arises from the first point's odd management structure. So basically in LLPs, there's no requirement for a proper business structure. There's no statutory provision for either a board of directors, company secretary, share allotments, etc. However, informally, from business to business, they can establish this, like other usual corporations, but this depends on the business's preference. My third point is that it can be sort of hard to raise funds in the business. They're not able to issue and sell shares that easily, so that's a major hindrance for new entrepreneurs because of the high amount of risk. Now that I've discussed the internal problems that LLPs in the UK face, I will go on to discuss the external problems faced by LLPs in the UK. The first is that they're subject to creditor protection. What is creditor protection? Basically, it protects defaulted borrowers from their creditors. In order to address the problem of creditor protection, some insolvency law provisions, which control directorial behavior and provide creditor compensation, must be applied. This just means more restrictions for the LLP members, which poses as pretty bad news. I will give two examples regarding this. In Section 214 of Insolvency Act 1986, it states that the court has a liability. The court has a liability to make sure that LLP members give in assets in case they withdrew any property within the past 2 years of it winding up. My second example, Section 2000. Section 2000 states that the court has a liability to make LLP members contribute within their own assets in case the LLP faces any sort of bankruptcy. Since a more personal agenda comes into this, the limited liability status of the LLP is reduced. The debt obligation is held on for 5 whole years, so there's no escaping from it. In April 2002, the limited liability partnerships came into effect in the UK. There were around 200 LLPs within that period over here. And now we can see in 2014, there are still very less LLPs in the UK. According to ONS statistics, in 2014, there are about 5 million private sector businesses in the UK. Within the 5 million private sector businesses, about 63% of them were sole proprietorships. About 29% of them were companies, and about 9% of them were partnerships. Within the 9% of partnerships, only 60,000 of them were LLPs. Recently, LLPs, they've come under a lot of debate with UK authorities and regulators. This is because of the lack of regulations and rules imposed on them. There is a lot of unclarity regarding the rules. I will give 2 examples regarding this. The first case relates to whether fixed share partners are considered actual partners or employees. In the case of the Tiffin v. Lester Aldridge LLP, the court held and ruled out that fixed share partners are very less likely to be considered employees. Many firms will draw comfort from this ruling. The second case relates to a hedge fund business, namely F&C Alternative Investment Limited. In this case, the court held and ruled out that LLP members do not owe fiduciary duties to each other. However, before, the court held and ruled out that LLP members do not owe fiduciary duties to each other beyond the contractual obligation. This poses as a serious contradiction. Due to this, it must be addressed by the UK Governments and Company House. Conclusively, there are many different business forms that an entrepreneur can choose from, and they must assess the benefits and limitations of an LLP, as is the case with any other business form before they start one.
To sum up, LLP is still considered to be a very new business forms in the UK. Whether or not to select or convert into an LLP is a very critical decision, and one has to identify a conclusive reasons to do so. So far, we have discussed what is LLP, the limitations and benefits, and why there are so few LLP in the UK. My name is Sun.
And my name is Javeria.
My name is He Qian.
We hope you enjoy our presentation. Thank you very much. There are many types of business forms and structures when you want to set up a business from a simple to a complex.
Then their privacy will be exposed to a large extent.
Sorry.
2009 regulations